A new law was also passed in Parliament today, granting the government powers to issue restraining orders and adopt a community-based approach when dealing with racial issues. The Maintenance of Racial Harmony Act takes close reference from existing legislation in the Penal Code and Maintenance of Religious Harmony Act. Parliament also debated changes to Singapore's constitution, which will allow the president to confirm, cancel or vary a restraining order if the cabinet and the Presidential Council for Racial and Religious Harmony have differing views. 7 opposition MPs voted against the constitutional amendment. Workers' Party MP Sylvia Lim raised concerns about giving the elected president the powers to decide on restraining orders made by the Home Affairs Minister. She says it is the government and not the president's responsibility to maintain public peace and order.
As our founding Prime Minister has said, the president is a symbol of unity and the personification of the state. Indeed, that is the president's central and defining role. To require him to make hard decisions on matters involving ethnicity will detract from his role as a unifying figure above politics. This bill envisages the president possibly confronting the cabinet on decisions that affect influential race-based organizations. For the president to enter the fray and to take a position on racial affairs could quite possibly lead to the presidency being polarized along racial lines. This should be avoided at all costs.
As I understand it, Ms. Lim is not objecting, the Workers' Party is not objecting to the RO regime, but what she does not agree with is the presidential review of the RO. And the Workers' Party's view is that the Parliament and the public checks on the minister are adequate, and there should not be an additional layer of checks through the Council, the Presidential Council, and the President. This is ultimately a question of judgment. The government's view is that Parliament and the public are essential checks on the minister's power, but that there is also considerable value in having an additional layer of check through the Presidential Council and the President, and that it is appropriate for the President, who is directly elected by the people, to act as a check on this power that can be exercised by the minister. And this is similar to the model we have adopted in other legislation, like the Internal Security Act and the MRHA.
MPs also raised concerns over how a restraining order, or RO, would be carried out. Under the new law, the Home Affairs Minister will be able to issue such orders against anyone involved in producing, sharing or communicating content that threatens racial harmony in Singapore. Under the restraining orders, a person can be disallowed from printing, editing, assisting or contributing to any publication and prohibited from holding office in an editorial board or committee of any publication. The 5-hour debate saw MPs field several questions on the restraining order.
So what I'm trying to establish is what is the system that the minister will be using, what sort of criteria, and will they be bound by legal precedents?
There would be a careful assessment made by the ministry, and obviously the ministry's lawyers would be involved, and almost certainly there would be advice taken from the government's legal officers, and then the minister will make a decision. But it will have to be a process that is swift and fast because of the nature of the social media. But at the same time, members will note that there are procedures for appeals and for the appeals to be dealt with. And ultimately, I've talked about the routes for challenging the minister's decision.
The power of racial content restraining orders is undeniable, but with that power comes an inherent challenge, balancing enforcement with the preservation of freedom of expression. How do we ensure that these orders are not misused to stifle legitimate discourse? These include artistic expressions like parodies, satire, or critiques of societal issues that touch on race. While some content may indeed cross the line, how do we draw boundaries between harmful speech and those forms of expression that are vital for a vibrant and open society?
I think we can look at the MRHA for reference. We have had similar powers for over 30 years, and the powers have never been used. That gives you an indication of how the government approaches these powers. The important thing is to have the powers, but also to be very, very careful and judicious in how you use them.
There were also queries on the Community Remedial Initiative. MPs sought clarifications on who is allowed to be part of the program and what it entails. Now, this initiative allows offenders a chance to rehabilitate instead of being prosecuted.
Can the MOS please explain the eligibility criteria for participation and whether completion of the program will be considered in determining future regulatory actions against offenders? Also, how can entities contribute to the broader objectives of such initiatives, potentially as partners in promoting racial harmony?
Current intent is for the CRI to apply to conduct that potentially discloses offences under the bill. But where the actions are serious, like incitement of violence, then CRIs, it's not the intention to offer CRIs. Those cases, the intention is to prosecute them. And the other point, because this relates to race, the CRI will not be compulsory. But failure to complete the CRI can be considered by the public prosecutor in exercising prosecutorial discretion whether to charge or not to charge. MHA will work closely with MCCY, onepeople.sg and community partners on structuring, delivering, monitoring the outcomes of such programs.